Hello everyone, welcome to Indian Current Affairs podcast channel. Today we are going to discussing some of very important MCQs related to Indian polity. Let's start the first question. Consider the following statements with reference to the Law Commission of India. First one, the Law Commission of India is a statutory body established by the Government of India. Second one, the primary function of the Law Commission is to advise the Ministry of Law and Justice on legal reforms. Third option, the first Law Commission was established in 1950 by the Prime Minister of India. So which of the following statements regarding Law Commission are correct? If you see, Law Commission is recently in news because 23rd Law Commission was formed by the Parliament. So in this regard, we have to know about what is Law Commission and its duties. So the Law Commission of India is a statutory body established by the Government of India. So this statement is wrong because it is not statutory body, it is executive body. So this statement is wrong. If you see second one, the primary function of the Law Commission is to advise the Ministry of Law and Justice on legal reforms. This statement is correct. Third one, the first Law Commission was established in 1950 by the Prime Minister of India. This statement is wrong. So it is established in 1884. So this statement is wrong. So only second statement is correct. First and third are wrong. If you see the explanation, the Law Commission of India is an executive body, not a statutory body. The first Law Commission was established in year 1834 under the Charter Act of 1833. Next question. Consider the following statements regarding the Law Commission of India. First statement, the recommendations made by the Law Commission are binding on the government. Second one, the Law Commission is constituted for a 3-year term. Third one, the first Law Commission of Independent India was established in 1955. So which of the following statements regarding Law Commission are correct? If you see the first statement, so the recommendations made by the Law Commission are advisory in nature. So those are not binding. So first statement is wrong. If you see second one, it's constituted for 3-year term. This statement is correct. The first Law Commission of Independent India was established in 1955. This statement is correct. So second and third are correct. First is wrong. If you see the explanation, the recommendations made by the Law Commission are not binding on the government. The Law Commission is constituted for a 3-year term. The first Law Commission of Independent India was established in 1955. Next question. Consider the following statements regarding the 23rd Law Commission of India. The 23rd Law Commission was constituted for a 3-year term starting from September 1, 2024. The primary mandate of the 23rd Law Commission includes reviewing and recommending the repeal of obsolete laws. Third one, the chairperson of the 23rd Law Commission must be a serving judge of the Supreme Court. Fourth one, the 23rd Law Commission will also examine the impact of globalization on food security and unemployment. So which of the following statements regarding 23rd Law Commission are correct? So first statement is correct. If you see the second statement, this is also main mandate of the 23rd Law Commission to reviewing and recommending the repeal of absolute laws. Some laws are there, those are very old and those are not adequate for present conditions. So we have to reviewing by this Law Commission. This statement also correct. If you see the third one, this is wrong statement. The chairperson of the 23rd Law Commission must be a serving judge of the Supreme Court. It's wrong. So retiring judges of the Supreme Court are generally chairpersons of the Law Commission. So third one is wrong. 23rd Law Commission will also examine the impact of globalization on food security and unemployment. This statement also correct. So 1, 2, 4 are correct. Third one is wrong. So the chairperson of the Law Commission is usually a retired judge, not necessarily a serving judge of the Supreme Court. So next question. Consider the following statements with regards to Article 30 of the Indian Constitution. The protection under Article 30 is confined only to minorities, those are religious or linguistic, and does not extend to any section of citizens. Second one, currently only those communities notified under Section 2 of C of the NCM, National Commission for Minorities Act 1992 by the central government are regarded as minority. In 1993, 5 religious communities, the Muslims, Christians, Sikhs, Jains and Zoroastrians were notified as minority communities. In 2014, Buddhists were also notified as minority communities. So which of the following statements regarding Article 30 are correct? If you see this one, first statement is correct. So minorities only related to religious minorities or linguistic minorities. So we don't consider any other minorities like caste minorities like that. So only religious or linguistic minorities are considered. So this statement is correct. If you see second statement also correct. So currently only those communities notified under section 2C of the NCM Act 1922 are considered as minorities. This statement also correct. If you see the third statement, so here the Muslims, Christians, Sikhs and Jains is given, but not Jain. It is Buddhists and Zoroastrians are first recognized as minorities. Jains later recognized as minorities in 2014. So here we have to replace Jains with Buddhists and Buddhists with Jains. This statement is wrong. So first one, second one are correct, third one is wrong. If you see the explanation, third statement is incorrect at first. Muslims, Christians, Sikhs, Buddhists and Zoroastrians were notified. After that, Jains are notified as minority community. Next question. Who among the following is eligible to vote through the postal ballots in India? Special voters such as President of India, Vice President, Governors, etc. Second one, service voters including members of the armed forces, paramilitary forces and government employees on election duty away from their home constituencies. Third one, electors on election duty. Fourth one, electors under preventive detention. So which of the following statements true regarding eligible to vote through postal ballots? Answer to this one is all of them are eligible to vote through postal ballots. If you see the explanation, in India, postal ballots are allowed for certain categories of voters who may not be able to cast their vote in person at the polling station. Special voters. This category includes the President of India, Vice President, Governors and other designated dignitaries. They are eligible to vote through postal ballots due to their special status and the nature of their duties. Service voters. Members of the armed forces, paramilitary forces and government employees who are on election duty far from their home constituencies can vote via postal ballots. This ensures that they can exercise their right to vote even when deployed away from their home locations. Electors on election duty. Individuals who are engaged in the conduct of the elections, such as polling officers and other election staff, and cannot vote at their assigned polling stations are also eligible to vote through postal ballots. Electors under preventive detention. Individuals who are detained under preventive detention laws are also allowed to vote through postal ballots to ensure their right to vote is not denied due to their detention. So next question. Consider the following statements. First one, the Defense Acquisition Council is the highest decision-making body for policies and capital acquisitions for the three services and the Indian Coast Guard. Second statement, the DAC is chaired by the Prime Minister of India. So which of the following statements regarding Defense Acquisition Commission are correct? So if you see first statement is correct. So for three services, Army, Navy and Air Force, they procure the equipment, and also for Indian Coast Guard also this is the council to procure the equipment. So first statement is correct. If you see, DAC is chaired by the Defense Minister, not by Prime Minister. This statement is wrong. So first statement is correct, second statement is wrong. If you see the explanation, Defense Acquisition Council is led by Defense Minister. Next question. Which of the following statements regarding Article 142 of the Indian Constitution is incorrect? So we have to find incorrect statement here. So it empowers the SC to exercise its jurisdiction and pass orders for doing complete justice in any case or matter pending before it, including cases outside the ambit of law. Second statement, the exercise of power under Article 142 by the SC is limited to the territorial boundaries of the India and cannot extend to Indian citizens residing abroad. Third one, under Article 142, the SC can grant relief even if there is a statutory provision contradicting the relief granted, but it cannot legislate. SC has utilized Article 142 to fill legal voids by providing guidelines in the absence of specific laws, which are binding until the legislature enacts a law to that effect. So which of the following true regarding Article 142. So under 142 article, Supreme Court can give complete justice with its absolute power. So it can give any justice, any sentence or any state, anything under this act. What I have to say is, it empowers the SC to exercise its jurisdiction and pass orders for doing complete justice in any case or matter pending before it, including cases outside the ambit of law. So if there is no specific law also, Supreme Court can exercise it. For example, in Ayodhya case, in Ayodhya Ram Temple case, Supreme Court under Article 142 give 5 acres to the Muslim body there. So it is to do complete justice, it invoke Article 142. So similarly, if there is no law also, they can do complete justice by invoking this article. Next statement, the exercise of power under Article 142 by the Supreme Court is limited to territorial boundaries. So this statement is wrong. Even outside the territorial boundaries of India, this power also applicable. This power is applicable. So statement 2 is the wrong. We have to find out incorrect statement. So this statement is the incorrect statement. If you see the third one, under Article 142, the SC can grant relief even if there is a statutory provision contradicting the relief granted. So what this means is, if any statutory provision is there, against also Supreme Court can give relief to the person. So, but it cannot legislate. So it don't have powers to legislate. That means Supreme Court cannot make laws. That's the meaning. SC has utilized Article 140 to fill legal voids by providing guidelines in the absence of specific laws, which are binding until the legislature enacts a law to that effect. For example, in 1998, like that, so there is no specific provisions to safeguard the women working in organizations or women at workplace. So then what SC did is, SC makes some provisions. Those provisions are called Vishaka guidelines. So SC provide some guidelines under Article 142. So those are applicable until new law is legislated about that matter. So this statement also correct. So A, C, D are correct, B is wrong. If you see the explanation, granting relief despite statutory provisions. The Supreme Court can issue orders or grant relief that may not be explicitly covered by existing statutory provisions. For example, if a law does not provide a particular remedy but the court believes that granting such relief is essential to ensure justice, it can do so under Article 142. This power is meant to ensure that justice is done even if existing laws are insufficient or inadequate in specific situations. Cannot legislate. While the Supreme Court can provide relief and make decisions to achieve justice, it cannot create new laws or make legislations. The function of making or amending laws is the responsibility of the legislature, parliament or state legislature. The Supreme Court's role is to interpret and apply existing laws, and its power under Article 142 is limited to granting relief within the framework of the law, not creating new legal provisions. So next question, how many of the following statements accurately reflect the theoretical and conceptual framework of the judiciary's role in a democratic setup as envisaged by the Indian Constitution? First one, the separation of the powers doctrine forbids any retired member of the judiciary from being a member of either the legislature or executive to ensure judicial independence. Second statement, judicial review as a concept in the Indian legal system is limited to examining the constitutionality of the legislative act and does not extend to executive actions. Third statement, the principle of judicial independence is rooted in the idea that judges must be able to perform their duties free of influence from the legislative and executive branches, as well as from private interests. So which of the following statements are correct? So if you see the first statement is wrong. So even though retired members of the judiciary can participate in elections and In some people also make as MPs in Rajya Sabha. So this statement is wrong. Judicial review as a concept in the Indian legal system is limited to examining the constitutionality of the legislative act and does not extend to executive actions. This statement also wrong. So judicial review applicable both to legislative acts and executive acts. So this statement also wrong. If you see the third one, the principle of judicial independence is rooted in the idea that judges must be able to perform their duties free of influence from the legislative and executive branches as well as from private interests. So the main concept of judicial independence is this one. So this statement is correct. So 1 and 2 are wrong. Third one is correct. In India, judicial review is both to the legislative act and executive act, but in case of UK it is only to the executive act. There is no review for legislative acts in Britain. So in Britain there is legislature supremacy, but in India it is constitutional supremacy. Next question. A judiciary that interprets laws in a manner that primarily benefits the government and its policies, thereby protecting their interests, breaches the principle of. So if a judiciary always supports the government decisions, then what it is called? And if a judiciary do that one, so which principle it breaches? So answer: assertive judiciary, committed judiciary, integrated judiciary, or competitive federalism. So if you see, it breaches the assertive judiciary. So what is assertive judiciary? In assertive judiciary, judiciary always favors the people. So in committed judiciary, it always favors the government. So what it means is, in assertive judiciary, if government makes any bad law, judiciary restrict that one and stop that law. But in committed judiciary, if it may be true or wrong, so in any cases, judiciary always supports the government. So then it is called committed judiciary. If you see the explanation, assertive judiciary means to protect the people from bad policies of government. Committed judiciary means judiciary always favors the government decision. It may be wrong or right. Judiciary always try to uphold the decisions of the government. So next question. Which of the following statements accurately reflect the characteristics and functioning of the subordinate courts in India? The establishment and organization of subordinate courts are primarily governed by the provisions under Article 233 of the Indian Constitution. Second statement: subordinate courts have the jurisdiction to try both civil and criminal cases as per the laws governing their functioning. Third one: the Chief Justice of the High Court concerned has the sole authority to appoint judges to the subordinate courts. So which of the following statements regarding subordinate courts are correct? So first statement is correct. So those are provided under Article 233 of the Indian Constitution. Subordinate courts have the jurisdiction to both civil and criminal cases. What is civil cases? Civil cases are anything regarding property. So like that. In criminal cases we all know. So subordinate courts can have jurisdiction to try both civil and criminal cases. The Chief Justice of High Court concerned has the sole authority. So this is wrong. So who appoint the judges to the subordinate courts? They are appointed by the governor under the recommendations of Chief Justice of the High Court. So this statement is wrong because governor also involved here. If you see the explanation, first of all, what is civil court? Handles private law claims such as disputes over property, money, marriage, divorce, and more. In civil cases, the plaintiff issues the defendant and the plaintiff must prove their case by a preponderance of the evidence. Criminal court handles cases brought by the state against a defendant accused of a crime. In criminal cases, the state controls the proceedings and the defendant must be proven guilty beyond a reasonable doubt. Session court, a district court that handles criminal cases when it exercises its jurisdiction under the Code of Criminal Procedure. Session courts can try offenders punishable with imprisonment for more than 7 years. So difference between civil court and criminal court and session court. Session court Session court is also criminal court, but it is lesser than session court. Session court can take severe criminal cases, which give more than 7 years of jail punishment. Criminal court judges can punish you for breaking the law by sending you to jail. Civil court judges can order you to pay money or fine, or make decisions about your family or your home. Next question. So this is the end of today's class. Thank you very much for watching.